Morning, everyone. Welcome to the Indiana State Board of Nursing for Thursday, April 16th. We will bring this meeting to order and establish a quorum. At this point, we have Nancy Youngst, LPN. We have Jessica Harlan-York, Dr. Scalf, Angie Morris, Jennifer Miller, Rena Majors, and I am Jason King. So with that, we do have quorum. We have 7 currently. We should be expecting, or 7. Okay, 7 currently, and we should be expecting 2 more members eventually. So moving to the next item, adoption of the agenda. Does anybody have any discussion? Questions, thoughts? Changes?
Second.
We have a motion to accept the agenda. Ms. Morris, seconded by Ms. Miller. All in favor?
Aye.
Aye. Opposed? Abstained? Motion carries 700. All right, we're going to jump down to the adoption of the ALJ recommendations. The ALJ recommendations for any questions, changes, discussion?
Thanks for using our mics. You might have to move it because it doesn't sound like our volume is very, make a motion to approve.
Okay, we have a motion. We have a second?
Second.
Second, Ms. Jones.
Yes, sorry.
Please use your microphone. Wait, we have a motion to adopt the ALJ recommendations. Majors, Youngst, all in favor?
Aye.
Opposed, abstained, motion carries 700. Moving on to the ALJ recommendations for April 2nd. Any questions, thoughts, discussion?
I make the motion to approve.
Well, I actually have one. Sorry. I was waiting for everyone else first. So I have a change that needs to be made, and they're on a couple of them. So. Okay. So I had already talked to Ms. Racine about these, but on number 10, 12, 13, 14, and 15, the way that it's presented, these people came to us for an opinion on criminal convictions. And we were trying to be very precise about our wording, and the way that it reads to me initially in the minutes was that we would issue and there would be sanctions. So I wanted to make sure that we have clarity so that future board. So is based on the facts presented today, the ALJ recommends issuing an opinion that their criminal conviction is not disqualifying, but that a future board might impose stipulations or sanctions at the time of issuance. So again, it moved it from more of a will or to a might. So that leaves our future board to possibly impose sanctions if they don't have to. So I just want to make sure that we're clear on that language. So again, Ms. Racine has already made the changes, so that's the only thing that I had. So with that, would you like to make the motion?
Yes, with those, edits, I would make a motion to approve. Major second.
Here we have a motion from Ms. Miller, seconded by Ms. Majors. All in favor?
Aye.
Opposed? Abstained?
Aye.
Motion carries 701. Welcome, Dr. Gallegos. All right, moving back to the adoption of the minutes of the meeting on March 19th. Any questions, suggestions, changes? If not, do we have a motion?
For that.
A motion from Ms. Morris. Do we have a second?
Harlan York.
All right, so we have a motion by Ms. Morris, seconded by Harlan York. All in favor?
Aye.
Opposed? Abstained? Dr. Gallegos, did you vote?
Aye.
Motion carries 800.
Can you give me a minute?
Sure.
Thank you.
Would you like to abstain from that last vote then?
That's fine.
All right, motion carries 701. Moving on to the adoption of the minutes of the ALJ meeting on April 2nd.
With those edits that we discussed with the ALC recommendations, I would motion to approve.
We have a motion from Ms. Miller. Do we have a second?
Thank you, second.
Ms. Morris had a second. All in favor?
Aye.
Opposed? Abstained? Motion carries 701. Moving forward on the adoption of the recommended orders. Any questions about these three? If not, do we have a motion?
I make a motion to approve the recommended orders for Savannah Rowe, Kevin, Lemon, Ricketts, and Diamond Charity.
We have a motion by Ms. Miller. Do we have a second?
Morris.
Okay, Ms. Miller Morris, all in favor?
Aye.
Opposed? Abstained? Motion carries 701. All right, moving forward to education. Ivy Tech Community College, Indianapolis construction site visit. Welcome, Dr. Hayden. So now we have a quorum of 9. Good morning.
Morning.
Yeah, you don't press it.
Good morning.
Yes. It's the opposite. Yes. Would you like to introduce yourself for us, please?
Dr. Diana Sheffield, the Dean for the Indianapolis Ivy Tech School of Nursing.
Thank you. Ms. Herring?
Ivy Tech Indianapolis is before you this morning for a construction site visit. The board may remember that the Indianapolis campus is relocating from the Lawrence or Fort Harrison location where they currently have been located for several years to their main campus downtown with the other facilities that are associated with the major functions of Ivy Tech. They have basically remodeled an entire floor. They are moving both labs and didactic downtown. It's very impressive, and I want to compliment my colleague, Ms. Keith, for the great pictures that she took and attached to your report. She is much better at that than I, so now you have a much better representation of what we see. But Ivy Tech has spent a lot of time in looking at the functionality of the space that they have. Sure that those things that we're concerned about with confidential spaces and discussions are there, in addition to very well outfitted skills and simulation lab. So all in all, we felt like this construction was equal to or better than what was left at Lawrence. And we would recommend that that be approved for immediate occupancy and use.
Very good. Dr. Sheffield, do you have anything more that you'd like to add?
No, our students are very excited about moving downtown and being closer to ancillary resources. And so we are excited. We're excited about leaving an older building and going to new construction. One of the things that Ms. Herring had suggested was having areas for students to store refrigerators and microwaves. I did count in the building, there are 10 microwaves, And we will be bringing a refrigerator with us to a smaller student lounge so that students have that ability to bring their lunch. We do have a large cafeteria in our building, which we're looking very much forward to as well.
Thank you. Board, any questions? The only question I had was, on Ms. Heron, you said for program concerns regarding late notice for scheduling clinicals with the adjunct faculty. Can you tell me more about that?
I would love to tell you, but I've drawn a blank.
Okay.
I will refer to Dr. Shennefield. Hopefully she will remind us.
So one of the things that we have issues with, especially being downtown, is that we have a lot of competition for our adjunct faculty. As most anybody knows, adjunct faculty are not paid as much as the hospitals. And so we have a lot of competition with getting adjuncts. So one of our issues is in the last couple semesters, we have had adjuncts come right to the day before clinicals and decide not to teach for us. To take overtime at the hospitals. And so we have been working hard with trying to make sure that we develop a good, strong adjunct pool. And we have somebody who now is dedicated with doing orientation with them, with doing professional development with them. So hopefully to keep them enticed with teaching instead of going for higher money at the hospital.
Very good, thank you. Appreciate that explanation. Any other questions? If you don't have any questions, do we have a motion?
Motion to approve. Second.
We have a motion to approve for immediate use and occupancy by Ms. Morris, seconded by Harlan York. All in favor?
Aye.
Opposed? Abstaining? Motion carries 9-0-0.
Thank you, Morgan.
Thank you, ma'am. All right, moving forward to St. Mary of the Woods. Good morning.
Morning.
Like to introduce yourself for us, please.
Yes, I am Dr. Marcia Ann Miller. I am the Dean of Arts and Sciences at St. Mary's of Woods College.
Ms. Aaron?
St. Mary's is here this morning to request a curricular change. You'll see from the documents that they've submitted that what they are doing is revising their curriculum to come into compliance with the AACN standards that have been recently revised. They've given you information about their BSN program as well as their paramedic to BSN program. And I think Dr. Miller has done a good job of kind of providing the information that the board would want to be able to make an informed decision.
Dr. Miller, anything you'd like to add?
Now, we did this very systematically over a period of the last 3 years. And we had to start with our overall program outcomes, which cover our graduate and undergraduate classes. And so when we changed the program outcomes, and that causes us to change course descriptions and core student learning outcomes. So we've aligned all of that, and then we have a teach-in program and a teach-out program that will start in the fall, if approved by the state.
Or any questions? Evidently, you've put a great packet together. Nobody seems to have any questions. I'm just curious, how many do you have usually in a cohort for your paramedic BSN?
So our paramedic is only for Indiana and Illinois at this time, and usually we run minimum 16, but usually the maximum about 22. We have had consistent cohorts. We're on our 5th cohort right now. The last cohort that just graduated in December was 16 students. They had 100% pass rate.
Fantastic. Yeah, I was just curious to see how big those cohorts were. But the paramedic science people are too happy with those, producing all those paramedics, but so congratulations. That's fantastic.
Thank you.
Board, any other questions? If not, we have a motion.
Motion to approve. I'll second.
We have a motion by Major, seconded by Morris. All in favor?
Aye.
Opposed? Abstained? Motion carries 9-0-0.
Thank you very much.
Moving forward in the agenda to Fortis monthly report. Good morning, all.
Good morning.
Please introduce yourself.
Joe Davila, I'm the campus president. Steve Literal, I am the interim dean of nursing.
Dr. Michelle Odie, VP of Nursing. Stephanie Fredman, I'm an attorney for technical work.
I'm Pam Pratt, the clinical coordinator.
Would you like to proceed with your report? Anything you want to highlight or have the board know?
Well, we're down to 4. This is our last quarter. The things that we did, include is, we do have a new, mental health clinical finally. And a clinical health clinic, yeah, I need to have mental. These 4 are, doing well, and, the last 3 that we had graduate, they graduated the beginning of this last term, which was in April. And we are expecting them to be successful on their NCLEX. One thing that I would make a note of that we do understand that our NCLEX pass rate for this so far for that last quarter went down to 40. So we were making a concerted effort to provide them with some extra help. One of the things we're doing for all of our graduates who have not passed the boards, have not taken their boards, because there's still people, hanging out there from a year or so, where we're offering Pam, one of the things that she's gonna be doing is weekly calls with them, going down the list, trying to get a hold of them. Help working with our coach, even though our coach has tried to stay in touch with all of the students, even the efforts that Pam has been doing to try and contact those students, so that we can help them, at times has gone poorly because the student doesn't answer the phone, or they make an appointment and say they're gonna be there and they don't. But we're offering, testing for them to make sure that they're ready. We will utilize, HESI, a version of HESI that we can go into and, see where their incompetence is, where they need to work on, and remediate with them. Along with, we are purchasing, we're in negotiations and purchasing Archer for them as well, and give that to them, 90-day subscription for free to help them get prepared. And if they've not passed, we're trying to be there for them to pass. And so, yeah, that's some of the things that we're doing to help.
What, if you don't mind sharing, if the previous cohort, the pass rate was 40%, and this new cohort, there were 3 graduates that you anticipate being successful, correct? What is the difference between those two cohorts that makes you believe that those 2 students will be successful?
They are motivated. They ask questions. They were good students when they were here on campus. They respond. They still respond whenever we're reaching out to them. They'll respond to us. I think that that's really a key is communication. And the others just jumped in and did not communicate.
Do you want to add something?
Yeah, I just wanted to say that, the previous cohort where there was the noticeable drop, just no matter how much emphasis was placed on the coaching and the follow-up and the preparation, did not, take advantage of the opportunities that they were given to be able to, get some boosting as they, prepared for NCLEX. Some of them just jumped right in and didn't feel like they needed the coaching, and I think that was a significant difference. And this group that we have that's finishing is very receptive to that. We've done the same thing with them that we did with everybody else, emphasize the need to make sure they're prepared. They're just more prepared. I think mentally, it's a different group of people and a different approach, and we provided the same for both, but
So outside the student engagement, have they had higher exam scores? Have the progression rates been better?
I'm gonna say they've had higher exam scores, but they've been motivated to study. Meaning, they worked hard for what they got.
Yes, I hear you. I think engagement is a large factor in that, but their exam scores also have some predictions there as well.
Sure, sure, and they've improved, that, you know, that, their, like their first score may have been here, and then the next exam, a little bit higher, a little bit higher. And for these last four, that's the way it's been, and so we've been able to coach them on how to take, test questions and how to be more responsive to learning how to remediate, as well.
And then I appreciate that you're trying to engage with students that either haven't sat for NCLEX or haven't been successful. Do you have a timeline of what that'll look like once this last cohort is finished? I think it's reasonable that some point there's going to be students outside of a certain time frame. What's that look like for you?
I'll take that one,
Okay.
because it'll hit my budget, right? First, let me go back a little bit. Someone had asked earlier about the files. We keep the files for 5 years, and then we send them over to iPhone storage, basically for the existence of the school, right? And then what I want to do is, besides the adding the tutorial that we're doing with all the students, right? We just don't want to cut it off in June. We want, if anyone still needs it for 3 or 4 months later, whenever we need, we're going to help them out. So, definitely we can get as many people. We might have our last student in June, but we're going to continue helping out wherever we need.
Okay. And then I don't, Ms. Heron or anyone that's more familiar with the academia side, is there any statute or regulation around the time frame for that once they do close?
No.
No. Okay. Thank you.
What's the date of the June graduation?
June, I want to say June 30th, I'd have to look at my calendar.
Yeah, it is.
June 30th.
Or any other questions? So knowing that we have 4 students left, graduation date June 30th. When do we want to see Fortis back for a final? I assume that would be the next step, is like a final. Let us know what has gone on to the students, make sure they passed, et cetera. Or is there an ongoing, or what does that look like?
If they complete June 30th, the earliest that they could test would be in the third quarter. So we would not realistically have results on them for 90 days after that. So
But we would at least know that they've passed.
we completed the program,
the
yeah.
program.
But it's not
Yes.
They would know that they finished the
Correct.
program, yes.
Okay.
So that would be the board's decision. Do you want to see them when they finish the program, or depending on what those final NCLEX results are?
Personally, I would say both, but I just wanted to know if we needed a report in the meantime, are we still doing monthly? They just need to show up for May and June, that come back in July, letting us know that these June 30th students have completed, and then come back at a later time for the NCLEX results. Does that sound reasonable? Anybody have any other thoughts around that?
Do you really need them to present themselves other than just receiving the report?
Personally, I think one more time, just as a closeout, I think from then, I think it would be a report on the NCLEX. I think maybe just some finality, but what do the rest of you think? So maybe just one more time in July, just kind of doing what you're doing now. Keep these monthly reports coming to us for May and June, and then we'll see you in July for the final conversation, and then we'll just get reports as to the NCLEX updates. Does that sound reasonable?
Yes.
All right, so board, do we have a motion regarding the report?
Session temporary.
I'll second.
Here we have a motion to approve the monthly report majors. Arlen York, all in favor? Opposed? Abstained? Motion carries 900. Thank you.
Thank you, everyone. Have a great day.
And then we have a couple FYI items. Ivy Tech Community College wants to director of quality improvement for nursing. CD is attached. And Hondros College names a new director effective 3/31/2026. All right, at this time, Dr. Gallegos, you are set for the pre-settlement hearing conferences. It has been changed to bring 3. But any tags who are here, room 3. Discussion items that will be you report.
Morning, Board.
Good morning.
Do you all have a copy of the report?
We do.
Fantastic. So, as you can see, right now we have, 562 open investigations. The average age of our investigative files is 5 months. The average age of our litigation files, or we have 210 open litigation files. The average age of all 210, which includes the post-discipline files, is 17.76 months. Of those, 173 are new complaints, so complaints that we have filed to you for the first time. And the average age of those is 8.44 months. In terms of litigation files that we have closed this year, there was a little issue with the reports, so that information is not on the printed version. I can tell you that we've closed 84 litigation files so far this year, 73 of those were in first quarter and 11 so far in second quarter. Ms. Racine did ask me to look at some stats for 2025, since we have not reported that time. In 2025, we opened 117 lit files. We closed 269. For all of the lit files that we closed, the average age was 32.1 months. Without the post-discipline files, we closed 195. The average age was 17.71 months. That seems very big. I can tell you that there is one particular file that is skewing that number, and that was the Lindsay King file from last year that all was closed, but turned out never to got a final order. So we finally finished that out last year. That file opened in April 2016. So that explains the elevated number. you have any questions?
Yeah, so I think you might have answered it, but I just have a curiosity question. As far as the post-discipline, is that once they receive that, once the final order has been submitted, then does it get closed out?
It gets closed out in our system.
Okay.
If they come back to, come back for probation withdrawal or the statement, something after the fact, then we would reopen that same file. So that open date stays the same.
So that has a potential to skew the numbers then too.
Well, and that's why I give you the numbers with the system.
Yeah, that's what I wanted just to understand, the post-discipline and the timeframe around that, so. Okay, that's-
Yes. All right.
And then for that one file, if we were to remove that, do you know what the average age would be? The one that was skewing it to the 17 one?
I can figure that out and come back a little bit.
It's okay, I'm just curious.
I can figure that out.
Yeah.
Or any other questions?
Right, thank you so much.
Thank you. ISNAP report. Welcome back.
Thank you. She's back. Anybody have any questions on the report? I will read the highlights. We currently have 317 nurses in active monitoring. This report was for March and April, since I wasn't here in March. We have done 19 intakes. In the last 2 months, we've seen a sudden uptick for some reason in our intakes, not sure why, but they have been going up. Roughly 65.5% of our RMAs are still remaining non-medically necessary or MAT. We are almost to 35% MAT and MNT. Adderall remains our top drug for prescription positives, and alcohol remains our top drug that most people test positive for. So.
Thank you, board. Any questions regarding the report?
I have one question.
Yes.
On the Indiana risk assessment system, is this in relation to, we had some really good conversation at a previous board meeting about someone that was on an RMA that didn't have a substance abuse diagnosis. Is this related to that conversation in regards to, because it seems like they might not have a substance abuse, but they might have issues of higher risk in, I'm trying to find the verbiage they use, reoffending or fiddling.
Right. So what my point in doing that was to explain that the IRAS is not designed to sniff out substance use disorders. Probation officers are not licensed to diagnose such things. In those situations, what the IRAS is looking at is it is looking specifically at what resources is this person lacking? Because the more resources an individual is lacking, the more likely we are to be using means to sort of fulfill those resources and those needs. So lack of stable housing, lack of food. And we do have a lot of our nurses who end up in those situations. They don't have health insurance. They haven't been to a doctor in a really long time. So the more resources that they don't have access to, the higher the risk is of them reoffending. Because if you don't have, I'll use food for example, if you don't have stable food, and most professional people are not going to go to a food pantry. Their thinking is going to be, because we've talked to our nurses about this, I'm not going to go to a food pantry and take food out of some poor person's mouth, right? Because they don't feel worthy of it being okay to go there, right? Because they had a job before, and because they have a substance use disorder or have done something perhaps that has caused them to lose employment. So we actually have nurses out there who are not eating properly. They're not taking their insulin. So those kinds of things make those risks go up. So what I was trying to do was establish that because it says low risk, that's not low risk for a substance use disorder. It's just low risk for low offending, for reoffending. And it doesn't mean that they won't for 100% reoffend. It just means the lower that number is, the more resources they have access to. So it wasn't in relation to anything other than to explain the difference between screening for an SUD and looking at what the IRS is.
I think that helps. Thank you.
Thank you. Director's report.
Good morning. So you should have your report The one thing that I wanted to actually report out on is final numbers, of our parent audit. So we began that, if you remember, back in January. We had a several step process, and we notified them several times, including a phone call. Based off of the change in our process, we audited 3% or 360 parents. Of those, 337 passed, 23 failed. So it's roughly a 93.61 pass rate. Those 23 that failed, we will be seeing those in the coming months. We will get those scheduled for an order to show cause. And we will have, officially closed our hearing audit. So, I think that's record timing. I appreciate, Ms. Karen and Ms. Keith. Sean really took this audit and ran with it, and we were able to really improve our processes. So I just want to say thank you to those that really made this possible. Our education team, so for the month of March, they did 7 capstone presentations, a construction site visit, full accreditation site visit, and initial accreditation site visit. We are extremely busy right now with new programs opening, and renovation and construction. There are several, programs that are wanting to do construction or in the middle of construction. So our education compliance team is very, very busy right now, and will be for the foreseeable future. The only other thing that I wanted to kind of update you on is we are, so I sent out a survey to the nursing schools asking for feedback on our certificate of completion process and how we receive those and processes. And based on that feedback, we're changing our process a little bit. So we just did an internal staff training yesterday. I am working with 2 schools as a pilot for this process before we really get hit hard with our summer graduates. So that pilot program will happen in the next couple weeks, and we will get our process kind of fine tuned, and then we will go live with the new process with all the schools after we do a training with all of the schools. So we will be busy in the next couple weeks to try to meet the May graduation timeframe. So we're hoping this will help, one, remove a little bit of stress from both the schools and the students. A lot of communication, or miscommunication, or not understanding how to fill out the certificate of completion correctly. So based on all those things, we're gonna just make sure our staff's trained properly, the schools are trained and understand what we need in order to process that student's application and make them eligible for influx. So, just like I said, that's kind of one of our bigger projects right now that we've been working on. So with that said, I think that's all I have. So if you have questions.
Or any questions? Thank you. Thank you both for your hard work and everything that you do for the education. So I appreciate it. It's nice to see all that growth in construction and bookings and all of that. It's nice that there's access. Right, so we were going to move on to the petition for new bags and the self-register. All right, so we'll wait for her to come back in. In the meantime, we'll do the proposed settlement agreements. Does anybody have any questions about 1 through 7?
I have one question on 6, but, okay.
Any others besides number 6? Okay, so if not, can we get a motion on Senor McLean, Holiday, Paul, Willard, and Hayden?
Motion for approval.
Right, so we have a motion from Ms. Morris, seconded by Dr. Hayden. All in favor? Aye. Opposed, abstained, motion carries 8-0-0. Ms. Miller, what was your question on say out loud?
Put into words what I'm express. I guess I'm not fully opposed to how it's written. I guess my only other concern would be the timing of it and how long this person will be out of practice. I'm assuming, maybe I shouldn't assume, but I would think by our precedent, we came back before us for a personal experience, a personal appearance, that maybe that would be the time that we would notify them of the requirements about like the nurse refresher course. I guess it all depends on time and when they come back, because if it goes even longer, then we have a bigger, maybe over 10 years. If I were citing on the respondent, I would hope they would want to know that information ahead so that they can be thoughtful in their decision in the future. And that, but there's a line, right? That could be completely different answers. But I also don't know that that's our responsibility.
I have a greater issue with this, beyond that, but Ms. Morris, did you have something you want to say first?
No, not really. I guess I just kind of maybe just to have some understanding, Mr. James, how I came to this recommendation.
So his license is already expired
Okay,
and he submitted a response to his notice of proposed default and he was just going to let his license, he wanted to surrender it. So, he knows his hearings today, and not appeared, so, the next best thing is that if you to get back to the surrendering of the license, he's admitting the violation, he is, admitting his facts underlying that violation, and just don't want him to surrender, then turn around and reapply for a license. So when he does come before the board and reapplies, you have violation, the facts underlying that violation, and you'd be able to see whether he's worthy for receiving a license at that particular time.
I think just for, for prior processes, I've done it this way in the past. I haven't seen one like this, but I'm sometimes not in here.
So, if I may, my concern with it is that we have always said that, like, when the respondents just say, I just gotta let it go, or I want to surrender, a lot of times we'll do a denial on that because kind of allows them to escape any kind of sanctions, punishments, whatever kind of terminology you want to use. And that's what I feel like this is kind of doing, is what's preventing this person from going and applying for a license anywhere else besides Indiana. So those are my concerns. Just, to me, it just kind of lets them off the hook, just to say, you know what, I'll just not apply for 2 years. And to me that, I don't know, we've just not done that before. We've always wanted to kind of talk it through and have kind of sanctions already imposed should they return. So that's kind of my thought. To me, this just looks like taking the easy way out.
I read it the same way, and I think maybe where I was, pausing is, it is expired. And so typically when they try to say they're just gonna surrender, they have an active that license. And so with it being expired, it kind of puts us in that window of what we've had in the past where there was a period where we couldn't do anything with an expired license. But I also agree, I wouldn't vote to approve a surrender. I historically don't. So what would our options then be on the expired license?
Well, that's what we just need to do today is decide whether or not you're going to accept the agreement or not. And then it would just be, what they would negotiate, given the choice and some of the state.
So
The personal appearance that we're not limited to impose sanctions for the future, right? If they come back with one a new license, it wouldn't be necessarily sanctions, but it would be like
you're reinstating with all of these factors, put place your license on a reinstatement through a term of probation and apply terms and things like that at that time.
Yes, that's correct. It feels similar to, like when we just did the licensing. It's just that was still out here.
Okay. So back to my question. Now, I understand what we're voting on today. What I'm asking you is what options do we have with an expired license?
So, and they're expired and they reapply, we can consider everything in the file, with the, they would have to answer the questions in the reinstatement application form. Have you ever required discipline?
No, I'm sorry, maybe I'm not wording it well. I'm not talking about say reapply. This respondent was here today and they're expired and this was a hearing. What options would we have in that case?
Oh, okay. So if he was expired,
Do you like that reinstatement?
I think it's within the amount of time, obviously, the amount of time that it's been expired, just like when we do the reinstatements, it's been more than the 3 years. That's something that check. I think that it just depends on the time.
It's not because of what we do today. Like if we were here and we don't have options when it's expired unless you're trying to reinstate. But otherwise, the only option we can have is to say if we reapply, things are coming for us, and we decide at that time. Just kind of how I thought when I was reading it, but we've had that pocket of time where we couldn't do anything, we could, so, we could clarify that, I think, in my heart.
Guess what I might add, he's not really surrendering his license, it's already expired.
I understand. I just feel like it's sidestepping the process and all I'm saying. It's just,
In consequence.
but I think that's what we're trying to get at is because originally he was for the final hearing and the default hearing, and I know we've got a response and all of that, but that's where we would head if we denied. And I think we're just trying to figure out then what would that look like if he decided to remain expired.
Okay.
Because it kind of seems like a big deal in what has transpired. And again, I just think that there should be, an appearance and some explanation, in my opinion. But again, if it doesn't get us anywhere, then I don't want to have to travel down that road. So, see what council says.
And I agree that if managed in this way, it helps safeguard Indiana, but there's still options for other states where that could potentially have a loophole.
I understand they have to,
And if you allowed this, and if you were allowed to bring it back up 6 years from now. Like, why not just deal with it? You know what I mean?
That was
Like, he's gonna then, if this is able to be brought up, let's say he applies in 6 years and then you have a personal appearance, you're supposed to have that happen in 6 years, but I don't, it's just like, why not? Why?
but I mean, the idea is that, well, in the future, he'll have to say yes to have you had in the past, but we're
What if
talking
he
about,
doesn't?
but we're talking about fraud and all of those other things, so that it's the person.
Well, then what if he doesn't, and then it doesn't apply, and then you've got this.
Right. That's,
go to Ohio and
Yeah.
like, right.
So Ned, how close are we? Because if not, should we just, all right, so how about we table this and let's, you can do some research on it and then we'll circle back to it if that's okay, or are you all right with tabling it? I think you prefer.
Right.
Okay, so let's. All right. That's what we'll do.
Yeah.
Okay, so let's table this and let's wait for, council to be able to get back to us. And we'll come back to it later. Is that okay? Great. I'll take your silence after. All right, Ms. Zelkovich, are you ready?
I am.
Okay, so we'll move on to a petition for review in the matter of the license of Mary Loney. No, I forgot to spell your name correctly, correct?
No, you pronounced it perfectly.
And then, is it?
What do you think? It's not, but
Yeah. So, 2 for 2 so far, probably. We're on the petition for review that will start at 9 a.m.
Yes, thank you.
The first one, source for has been continued and we're on this voting.
Sorry.
Okay, so we will swear in our court reporter first. For the official reporter designated for this hearing, please stand and raise your right hand and be sworn. You would state your name.
Jessica Owens?
You solemnly swear or affirm that you will keep complete true notes of all that transpires in this hearing, prepare a complete transcript thereof from your notes and faithfully perform all the duties imposed upon you as an official reporter under the laws of the state of Indiana. Thank you. This is an administrative hearing taking place on April 16, 2026 in Conference Center Room C of the Indiana Government Center Building, 302 West Washington Street, Indianapolis, Indiana, at 9:23 a.m. local time. It's being conducted pursuant to the laws of the state of Indiana. So on the Indiana Code Title 4, Article 21.5, for 8 members of the Indiana State Board of Nursing and the cause act administrative cause number 202602 NUR 0038. The petitioner's name is Mary Musa Boating. The hearing is being held pursuant to the request of the petitioner based on the petition for review of license renewal denial for the renewal application of Mary Boating. The time and place of this hearing was served on the parties required by law on March 24th, 2026. My name is Jason King. I'm serving as hearing officer of this board. The following members of the board are seated with me on this hearing. Nancy Youngs, LPN, Dr. Hayden, Jessica Harlan York, Dr. Scalf, Angie Morris, RN, Jennifer Miller, RN, and Rita Majors, LPN. At this time, I request that any board member who believes that he or she cannot give this respondent fair hearing run an impartial decision to remove himself or herself on this hearing. As a reminder, this hearing is open to the public and being streamed live on the internet. It is responsibility of the parties to the council to ensure any protected health information or other confidential information necessary to the parties' case achieve PT identified prior to disclosure. Failure to properly protect patient information could result in objection and exclusion of testimony of witness. May we have appearance of counsel, please?
Yes, Attorney Adriana Zalkovich from this case.
Okay, and is Ms. Bodie your only witness today?
Well, Ms. Racine may be as well.
Okay. So all those who know themselves to be witnesses and may be witnesses in this cause, please stand and raise your right hand and be sworn. That concludes you, Ms. Bodie. Stand. Do you and each of you solemnly swear or affirm under penalty of perjury that testimony about to give in this cause be the truth, the whole truth, and nothing but the truth? Okay, and you seated. Parties of the matter hereby notified that the board will take official judicial notice of this file on the record in this matter. Do you have an opening statement for us?
I do, and honestly, I do hope to do this by summary because I think, procedurally it is appropriate, and then obviously I'm prepared to take testimony if we need to. As you can see, I'm sure that you have, respondents 1 and 2, which are honestly just condensed versions of documents that are already in the file. I just prepared them in case we need to go through them. It may be easier to refer to them that way instead of the board trying to scroll through the entire file. I'm not sure what it looks like on your end, but the way that we received the documents was essentially one long document, so there was no way to point chronologically to things that have happened. I think that this case is actually pretty simple, given the fact that on November 25th, Ms. Bodie was provided a notice to personally appear before the board on December 11th. That notice requiring her to personally appear before the board
indicated that she was appeared before the board for a positive response. It didn't provide any additional information as to why the board was going to see her, which caused a little bit of confusion, given the fact that she didn't have any positive responses on her application. She followed up with the board and I think determined that the board was proceeding with this after indicia that she was on a list related to Operation Nightingale. Most relevant to this is that this matter was already thoroughly investigated. It came before the board in 2023 already. First, the Attorney General's office received a consumer complaint, and as a result of that consumer complaint being filed, the Attorney General's office filed for summary suspension. If you look in Respondent's Exhibit 2, she did write a letter summarizing all of this ahead of her personal appearance.
So we've been asked that you go ahead and admit them into
Oh.
evidence.
I will, I would move to admit Respondents 1 and Respondents 2. These are all documents already in the file, just organized.
Okay. Respondents exhibits 1 and 2 admitted into evidence.
On December 8th, 3 days prior to her personal appearance, Ms. Bodie submitted a letter kind of summarizing the chronology and also providing a variety of documents to the board. My understanding is that at some point, this was not either received or the board member who was the ALJ was not able to open these documents during her personal appearance. And following that, I did not represent Ms. Bodie at the time. And only represented her after the decision regarding the right license renewal. But if you look on page 2 of Respondents 2, the petition for summary suspension is included. That was filed February 2023. After that, it is that petition, I believe, goes all the way to page 13. And then after that, you will have the initial consumer complaint that was filed February 7th, 2023. And that consumer complaint was filed regarding Operation Nightingale. Moving through that packet, I have, so. If we move it through that packet, the minutes of the February 16th, 2023 board meeting are also included, at which point this petition for summary suspension was withdrawn and the matter remained open as an investigation with the Attorney General's office. And I think most relevant to this case is the fact that this matter was investigated for a period of almost 2 years and was closed by the AG's office on August 1st of 2025. Ms. Bodie did submit that, but I'm not sure that that submission was available to the ALJ at the time of her personal appearance. So despite her cooperation with what would have been a due process, that the ALJ had every right to investigate this matter, she cooperated with that process and the case closure. When she petitioned to renew, she essentially went through the same process, except it was much less formal. She didn't have representation and she really didn't have any access to any of these old records, that she anticipated that this matter was over in August of 2025. So our request would be for a renewal, for her renewal to be granted, as the board has taken the same action for individuals who had case closure letters. Their matters that were set for personal appearances on December 11th, when the case closure letters were presented to the board director, that matter was closed. That personal appearance was vacated. So in line with board precedent, there's nothing different about Nurse Bodie's case, that the license should not have been renewed. At this point, I mean, the most appropriate way to prove any issues regarding her license renewal would have been with the Attorney General's investigation, and had there been evidence, the Attorney General's office would have filed an administrative complaint, and then this would have proceeded to a full hearing in front of the board. At this point, there's nothing. She's in a position that she would be subject to this every single renewal cycle. And that's not due process. She has a constitutional property right to her license. And she has, with that comes a due process right to a full hearing. That's not what happened in the personal appearance. But also, she should not have, my position is that she should not have been subject to that personal appearance in the first place, given the fact that she had a case of closure letter that should have been, I believe, in possession of the board at the time. So I'm not really sure what the miscommunication is. So if we proceed, you know, I've been taking testimony from Mr. Racine regarding those procedural things, and some of that communication, but that should have already been, in the possession of the ALJ, and my understanding based on my review of the letter that was issued is that it likely was not, given the fact that what the minutes and record indicate is that the documents were not acceptable.
I know that you said you wanted to take it by summary. Were you going to call witnesses?
I can call witnesses, but I was hoping that the board would address this issue first. So if we need to move to hearing, I mean, obviously I'm prepared to have her testimony, but strictly on the procedural issue, the board's precedent, and this would be essentially a due process violation because one individual with the exact same scenario was treated differently, and this would, you know.
So my advice would be, the board does not advise, the board acts. So I would advise that she makes her arguments and proceed with the hearing, and then we address them all during our deliberation.
Well, the request is for the renewal, though, and it is based on the pleading. It will be set for a hearing. I'm not really sure. I mean, we did subpoena a witness and exhibit list. I don't think that the board has presented one to me. Although we did get a copy of the file, the board has not presented a witness and exhibit list to me. And so in terms of being able to prepare for witnesses that the board would be able to offer, I am not aware of who the board would be.
I don't think the board is planning on calling anyone. And you're reviewing your client's qualifications.
The renewal decision was already made.
And you were have petition to review it, and we are having an evidentiary hearing on it now.
But there was not what I'm indicating procedurally, there was not a basis to deny the renewal.
So make those arguments as part of your presentation, and the board will address them during their deliberations.
I guess what I'm trying to explain is in terms of the procedural process, if there's not going to be any evidence to indicate the reason for her denial, my position is that the board could make a decision based on the summary because there's been no evidence presented to support anything regarding the denial.
And that would be something that the board would address during its deliberations, and if there was a dispute in that, it could be addressed during an interview.
Well, at this point, I don't know that there's any reason to call my client first. I would call Ms. Racine. Ms. Racine, if you could just state your name and your position.
Audrey Racine, AUD, REA, I'm the director of this NESD Learners.
And I'm sure the board knows, but could you please indicate how long you've been employed with the professional licensing?
I've been with professional licensing since March of 2024.
And how long have you been the board director?
Since August of 2024.
And are you familiar with the licensing process for nurses?
Yes.
And what is that process to obtain an RN license?
To obtain one or to renew one?
To obtain one.
So somebody would apply online normally or by paper. Submit, if it's by exam, they would submit, documentation that they've completed the CBC, which is a criminal background check, that they've, registered for NCLEX. We also receive their, certificate of completion by their school, and or if it, is a foreign applicant, that's a different process. And if it's by endorsement, we get their license information verification from the other states. We also get transcripts, and I think what else? That maybe,
So without meeting those requirements, an individual would not be issued a license, is that correct?
correct,
And to your knowledge, was Ms. Bodie issued a license?
yes.
Are you aware of when it was issued?
So she was, first issued an LPN license on August 24th of 2017. And then she was issued an RN license by endorsement from New York. Issued a license on June 24th of 2021.
And she received a notice of personal appearance on November 25th, 2025, correct?
Yes,
And she did in fact appear on December 11th, is that correct?
yes.
And prior to that, was the board in receipt of any correspondence prior to her personal appearance?
Just checking the documents, no deeds of those.
And I'm sorry, I have no way to tell from the way that it was transmitted.
Just a second. So everything that, I'm seeing is like communication that she sent in December. And I noted that her personal appearance was December 11th. I think, did you ask?
Yes, I'm asking if anything was received by the board prior to December 11th.
Yes,
And would that have included the letter that she wrote on December 8th, 2025? And that would be page 1 of response to.
So I'm not seeing that letter.
Would you agree that that letter was provided in the subpoena response?
Trying to. Might be. It was mailed in, correct? It wasn't.
I believe so. But I do believe it was also emailed. And I think maybe the timing, I don't want to take up any unnecessary time, but maybe the timing may not be so relevant. Is it possible that the ALJ at the time may not have had that letter, the documentation from Nurse Bodie, additionally, the documentation from the Attorney General's office and the case closure letter?
So I have a letter from December 9th. It was a written letter. The beginning of then number. And another letter from a family member. And there's several emails from Sophie, but,
And would you agree that all of that information would be in the current file?
yes,
And would you agree that some of that information, and I'm not saying it's complete, but would have included some information regarding classes, books, rubrics, grades, tests that were taken, clinical hours that were completed?
yes,
But is it possible that the ALJ may not have had those on December 11th or had access to them?
she did,
She did have access.
she did, yes.
And so if the ALJ indicated that she was not able to open those, were you made aware of any of those issues? No. In regards to the petition for summary suspension, that is pages 3 to 8 in Exhibit 2. The consumer complaint is, pages 9 to 10, and respondents to meeting minutes, are 11 through 23. Is it accurate that the state actually withdrew the petition for summary suspension?
Yes,
And the consumer complaint was not closed out, it was still in existence at the time, correct?
correct.
Page 24 of respondents to, is that a case closure letter?
Which page?
24 of respondents to, I believe, is the case closure letter.
Was the letter?
Is that dated August 1st, 2025?
Instead of one, page 21.
Okay.
So it says it's exhibit, respondents, it's about 4, but it's. Yes.
And would you agree that that letter is from the Office of the Indiana Attorney General?
Yes,
And that indicates that the consumer complaint has been investigated and closed?
yes,
And from the time of the consumer complaint, February 7th, 2023, till August 1st, 2025, over 2 years have passed, correct?
correct.
So at no point did the Attorney General's office take any additional action or find it necessary to take additional action against Nurse Bodie according to your file, is that correct?
Correct.
In terms of individuals that were listed for personal appearances, were there other individuals related to Operation Nightingale previously listed for personal appearances for December 11th?
The minutes, but possibly.
And are you aware of any individuals that provided case closure letters from the Attorney General's office whose personal appearances were then vacated?
I believe one.
Was there anything provided other than the case closure letter from the Attorney General's office that resulted in vacating that personal appearance?
Yes.
What documents were provided other than the case closure letter?
Well, not in regards to what documents were provided, but what documents I had in possession that made the determination of vacated.
And what factored into your determination in order to vacate that hearing?
Looking at the FBI affidavits that we had received throughout the course of their ongoing investigation.
Are those the only documents that you referenced?
Yes.
Would you agree that those same documents would be applicable in this case?
Some, again, going back to the other case, I don't remember specifically. I have to look up exactly which they were from and what time period that was.
Would it have been appropriate, had the board received the case closure letter ahead of the personal appearance, would it have been appropriate to vacate Ms. Bodie's personal appearance?
No.
Why not?
Because of the affidavits that I had in possession at the time.
What is the difference between those affidavits and what? is
There are
the reason?
several schools that were under investigation. We have received several affidavits from the FBI in regards to students that they have identified that received fake transcript. Some of those affidavits included lists of names of students, the owners or the individuals that were running these programs provided lists of names of who they believe received a fake transcript from their school. And so with that in my possession and with this Bodie's name on that list, I felt that it was pertinent that the board review her qualifications.
But would you agree that the individual whose appearance was vacated was also listed?
I don't know. I believe that that's why it was vacated, because they weren't on that list. But again, I'd have to go back to the specific person and look at their records again.
And I am not able to obviously implicate somebody else. But is there a way for you to verify why that hearing was vacated first appearance of Bodie's hearing?
Yeah, let me see if I can. I believe the other individual that had a closing letter reached out about was from a different school, and I could not verify their name on any list that was provided to us.
Would you agree that that's in direct contradiction to the summary suspension petition filed by the state?
There were some affidavits that were specified that during a certain period, we received updated affidavits as an ongoing basis where they would attach actual names of individuals. I was not able to locate that attachment or that name on the list in regards to this other school. And so I felt that because I couldn't verify that listed out.
But would you agree that the board referred individuals listed on that to the Attorney General's office via consumer complaints?
Not all of them.
Is there a reason why the board would not have notified the Attorney General's office regarding this thing?
Because as an ongoing basis, we did not know at the time, I believe, this was before my time, before I was at the PLA. Didn't know all of them that were included. So as an ongoing basis, NCSBN would update and provide updates every so often as to individuals that were named or they continue to invest. I mean, the investigation is still ongoing. So I have received an updated affidavit as of February 2026 for MedLife Institute, which is the school that this Cody went to. So we continue to get updated information on an ongoing basis.
But would you agree that the state Attorney General's office filed a petition for summary suspension in this matter in relation to Ms. Bodie, correct?
Yes.
And in terms of the filing, the investigation, there was an affidavit executed regarding MedLife. So in 2023, this was known. This is not new information to the board, correct? And I would just point you to the state's petition for summary suspension, which would be, it would begin on page 3 of respondents 2. And I believe under the section facts supporting findings of clear and immediate danger, the state goes through that process. And I would point you to paragraph 12, which indicates an affidavit executed by the owner and operator of MedLife, Joan and Point, identified respondent as a person who was issued a degree in transcript from MedLife without having completed the required program hours and clinical training necessary to obtain an associate in nursing degree.
Correct.
And so those were the allegations made by the state at the time.
Correct.
And so in 2023, those allegations were made. They were part of the consumer complaint. So all of this information was following that. the Attorney General's office proceeded to conduct an investigation that lasted until August 1st of 2025, correct?
That's when I closed their case, yes.
And after that investigation, they closed their file as to Ms. Bodie, not filing further administrative complaint, not filing anything else regarding, in any attempt to sanction her license, correct?
Okay. Maybe I Attorney General's office.
That's up, I'm so sorry, but that was the end of my question. Okay. And in regards to the affidavits received from the board by the board from, federal investigators or the FBI, is the board intimately involved in the federal investigation?
Can you define intimately?
Is the board participating in interviewing witnesses, participating in any interviews or viewing the interviews prior to any plea agreements being executed, affidavits being signed? Does the board have any access to the actual evidence other than the affidavits being provided?
No, just affidavits can provide it.
Is the board aware of any incentives, plea agreements, cooperation that these individuals signing these affidavits are privy to or being offered by federal investigators?
Speaks to their investigation.
So would you agree that you're not aware if there's incentives or reduced sentencing or any kind of immunity or cooperation that favors them as a mitigating circumstance that's being provided by federal agents to individuals like that?
We have them provided plea deals, copies of plea deals along with those affidavits, for folks that can continue to investigate.
I understand. And I'm sorry, maybe that's a bad question. More specifically, are you aware of what conversations are taking place prior to plea agreements? Are you participating or aware of any negotiations that take place prior to plea agreements being signed? Thank you. And in regards to Ms. Bodie, other than the consumer complaint filed February 7th of 2023, has there ever been a consumer complaint filed against her?
I would admit that.
What, the board wouldn't have a record of that?
No, not if we are not privy to consumer complaints filed by other folks outside of the board.
And is the board aware of any other than related to Operation Nightingale and the filings in 2023 by the Attorney General's office and the Attorney General's investigation that ended in 2025? Is the board aware of any other disciplinary action ever taken by Ms. Bodie, against Ms. Bodie?
No.
And the board's file doesn't include any kind of sanctions or any other litigation files, is that correct?
That's correct.
And would you agree that if an individual was on a list and Ms. Bodie was on a list, and the Attorney General's office provided a case closure letter to one individual, but not to Ms. and to Ms. Bodie, but one person's appearance was vacated, and the other person's appearance was not vacated, that would be disparate treatment?
I disagree. They have different facts. I would also say that the Attorney General's office, I believe, it was my understanding that they closed all cases and did not move forward with any cases whatsoever. So.
Would that be for a lack of evidence?
Not necessarily.
Okay, would you agree that Indiana statutes allow the Attorney General's office to prosecute individuals if there is evidence to move forward with their prosecution? I'm so sorry, I'll rephrase that question. Would you agree that statutory authority allows the Attorney General's office to prosecute individuals if there is evidence indicating that they have fraudulently obtained their nursing diploma?
I would say yes, it allows them to do that.
And I would specifically cite to a couple of statutes that allow this action. One is going to be.
Before we go any further, this is outside of the scope of the normal testimony of the board director. I'd like for her to just take a minute to see if she's a state employee, if she would be eligible for representation by our litigation division. I just want to ensure that she doesn't want to do that. So can we take a brief recess so she can address that?
I guess my only response to that would be that my client has been deprived of her ability to earn a what, if I may just respond.
It would just be going upstairs to get her a lawyer.
Understood. However, once you indicated that this is not adversarial, that this is our request for review. And so in regards to moving forward, I did ask in what preparation there would be for any kind of exhibits or witnesses that would be presented. And so in the situation, if there's going to be a lawyer involved, that does kind of change the schematics of how this hearing is proceeding. And I believe that there was notice, I mean, we did file this some time ago, requesting the review in February, and so.
Once Christine has decided that she's okay and would like to proceed, I just want to give her that opportunity as her right as a state employee.
Understood. In regards to Indiana Code 2523-126, that there's indicia that it's the duty of the Attorney General to represent the board in any court in which action may be filed for review. The Attorney General also may at his discretion call to assistance in such action the prosecuting attorney of the county in which such action is filed. And the reason I cite to that is that also Indiana Code 2523-127 indicates that a person who sells or fraudulently obtains or furnishes any nursing diploma, license, or record commits a Class B misdemeanor, which obviously is, criminal charges could be filed. So there was indicia evidence that Ms. Bodie had committed a crime or fraudulently obtained her nursing diploma. There are, Ms. Racine, would you agree that there are actual legal remedies and due process protections for a process to evidentiary process to move forward?
Yes, but I'm not speaking on behalf of the Attorney General.
No, and I'm not asking you to. I'm indicating, would you agree that there is a process to move forward? And so, if there was evidence specific to Ms. Bodie, do you have evidence specific to Ms. Bodie that would indicate that the classes she was participating in, that the coursework that she was doing, that the tests that she was taking were fraudulent? Do you have any evidence specific to her to indicate the same?
So based off of the lack of action by the Attorney General's office, the board has the authority on renewal to require licensees to present information to make sure that they still qualify and are eligible for the license that they have. So the board, on a personal appearance, based off of the information that the board had and no action being done, further wanted to ask Ms. Bodie questions related to her education, where she obtained that education, how she obtained that education, including clinicals, where she completed those, and that's all part of the personal appearance that she attended with one of our board members, where she went through and she looked at all of the information, including her testimony, and made the decision to deny the license based on her listening.
Would you agree that Ms. Bodie was issued a letter approximately less than 3 weeks actually prior to her personal appearance? The letter was issued on November 25th and the personal appearance was on December 11th.
The notice for the personal
Yes.
appearance? Yes.
Okay. And would you agree that in that letter, the board did not specify what documentation the board was requesting from her, correct?
Correct. It's a template letter.
So would you agree that she was not on notice as to the specific deficiencies that the board was indicating?
I have to go back. If she may have reached out asking for clarification, and we explained it was related to her education, but I deal with a lot of different applicants and licensees, so that I believe that happened prior to her personal appearance.
But do you have any knowledge that she was told what the specific deficiencies were?
Related to her education and her transcripts, and that is why she submitted the day before her personal appearance a lot of additional information about how she did her clinicals, emails, letters, documentation that she submitted prior to the personal appearance.
I'm just trying to ask a very specific question. Did the board ever tell her, these are the things that we're questioning, these courses, these clinicals, so that she could, in an effort, and I mean, this is in 2025. Obviously, she got her nursing license here in 2021, and this is several years after she was in school. But did the board ever provide her a list of any kind of specific evidence that she needed to show so that she could have her license renewed?
So we just told her to remove her education.
And then in the letter that was issued, in regards on January 21st, 2026, the denial was based on her attending MedLife Institute in Florida, and a summary of what she reported her education was. However, there's no reference to any of the documents that she provided, and some of those documents would seem to directly be in direct contrast to what is summarized here. When did the board, I guess you're indicating that she provided a lot of records. When did anybody from the board review those records, and give her any feedback as to anything additional that was missing or anything additional that she could provide?
I was not in that personal appearance. So those personal appearances are in a separate room with a separate, so one board member, I have another staff person, I've got advisory in there. So what is in the minutes is what I know.
I'm asking prior to that, when she attempted to resolve some of these issues ahead by submitting some of this documentation, did anybody reach out to her and say, okay, I see some of this, but what we feel is still deficient is this, this, and this? Was anything like that ever presented to her?
No, that's not a part of our process.
Thank you. At this point, I don't have any additional questions for Ms. Racy.
Or do you have any questions for Ms. Racine?
Mr. Racine, can you describe the process that when we notify a respondent, do we delineate every piece of document that we want them to bring with them to their personal appearance?
No,
So is it safe to say that if someone had a DUI, do we request all court documents or anything relevant to that?
no.
I have a couple questions, because I'm a little confused about the timeline. So when she appeared for personal appearance, what did she answer that caused her to be brought in front?
So part of the FBI writing Yale, NCSBN has on a continuous basis flagged individuals when they receive new information. So a part of that is she was flagged and there was a hold on her license.
So she wasn't brought though in front because she answered positively. I think that's what I'm confused about. Okay.
No.
So she was brought in front of her personal appearance for that, not because she answered yes, no, whatever. So, but that is allowable within the rules and regulations of the board, or yes or no?
Based off of my understanding, yes.
Okay.
Can I ask one more question? From your knowledge, the FBI investigation in relation to these schools was new for everybody across the nation, is that correct?
Correct.
And the beginning of the investigation produced little information, is that correct?
Correct.
And then as the FBI investigation evolved, they shared additional information at various phases, which was multiple phases of that, is that correct? So would it be safe to say, Indiana, IPLA's approach to the information they were receiving changed as we received additional facts?
Correct.
So someone who could have been heard at the beginning of this investigation might look different than somebody at the end of this investigation, is that correct?
Could be, yeah.
Okay, sorry. One more question. So, she was brought not because of a positive answer. Can you clarify what she was told she was brought in front of for?
So our personal appearance letters are pretty generic. It's a standard template. It just says, it could say, and I don't know the exact language, I have to pull it up.
If I may, it's respondents one. It's in response.
So it's very generic. It just says, you know, we'd like to essentially inquire about your renewal. We have questions on your renewal application. You're scheduled for a personal appearance with the board member, kind of thing.
Okay. I think, so, but there weren't questions about her responses. I mean, there were questions. Right,
She was identifying.
okay, but if she,
But just to clarify, just because they don't have a positive response on the renewal, we will still schedule them.
correct,
So.
correct, but
My process with evaluating renewal applications is if we have information, let's say somebody was arrested, but they didn't disclose it on their renewal and we have that information, then we will still bring them before the board so that they can help explain why they didn't
understood,
disclose
but
that.
then what are they told? So, understood, so,
It's the same.
so they have to come in front of the board.
They can email, there's some contact information on there. If they've got additional questions, they can reach out to the board to get clarification, which happens on a regular basis.
Got it.
And I believe the respondent also had communication with MPL in between when she received this notice and before she became before her PA, is that correct?
I believe so. I'm trying to look. There's several and not like. I communicate with a lot of different people, whether it's through my individual email or through our PLE2 inbox. As well as we have the clerk inbox, so there's several ways of communicating, so, we did receive her transcript on like December 8th and she was scheduled for December 11th. So, which made me believe that we did have some type of communication as to what was missing or what we needed because she was sending in this information about her education. I just can't find the exact communication right now as to when we communicated with her. Thank you.
Do you know, Ms. Racine, which, I'm trying to find the letter that she was given telling her to appear.
I believe council said it was respondent.
Okay.
Yes, it's in respondents one. It is the first thing after the verified petition for renewal.
Okay.
For you, I think it would be, page 6. And it is a very specific letter, that indicates there's a personal appearance regarding your nursing license. If you have not already done so, please provide any documentation that you feel may be relevant to your positive response.
Clarify everything. Ms. Racine, does this licensee or does she meet criteria that you described for licensure?
Based off of her personal appearance, on December 11th, the board member felt that she did not, based off of the information that she had at that time. Specifically, also the FBI affidavits and information related to the investigation, questions related to her clinical and whatever else that she may have asked in the personal appearance.
So are there variations from state to state on clinical requirements and educational criteria?
I think Ms. Hare would be better to explain the education piece than I would.
Is, to your knowledge, do you know if this respondent is still a part of an active investigation with the FBI?
I cannot say for sure, because I'm not part of that investigation, but as of, I believe February of 2026, we had gotten a new affidavit in regards to all of the different med life incidents.
And when did you say that was February of 26?
So it's an ongoing investigation. I can't say whether or not this person is still a part of the investigation, because I'm not a part of that investigation.
Okay, in that information from February of 2026, to your knowledge, she's not personally listed in that piece of it.
She's not personally listed. It's just an affidavit specifically stating the program types. And anybody issued after a certain date was not issued a legit transcript.
And so, given her circumstances, does she meet that information?
Based off the affidavit, she was issued the transcript after.
And I guess I would object to this as we don't have the affidavit in front of us, and I'm not really sure what affidavit we're referring to in dates, and so there'd be a lot of lack of foundation for some of these responses, and it would be something that I would need to
That's
understand.
fine, I'll just withdraw the question.
Sorry, and I'm not trying to be difficult, I'm just trying to say these affidavits were not accepted by the board as evidence at the hearings, and so my objection, and for the record, is related to the fact that if these evidence are not accepted as evidence, one, they're complete hearsay by the individuals that signed them. It is retroactively disciplining somebody who came before the board, was investigated, provided documents to the AG's office, the AG's office closed it.
I think that we're still dealing with board questions, still not maybe part.
I understand, this is part of my objections, I just want to know the basis for
I
my,
don't think that there's anything to object to. She went through her question.
well, there was a series of questions that I would indicate. Okay, I would move to strike any of the questions and responses related to the affidavit, as that is not part of the record or hasn't been presented as an exhibit. Yes, it's part of these exhibits.
But I guess Ms. Racine, from your perspective, with the case with the AG's office disclosed, it is your position that she still does not meet criteria for a license?
Correct. So I don't believe any of those individuals, I don't believe the OAG has moved forward with any of those individuals. So the board, based off the information we had and the information we continue to receive, we're just addressing them one by one. Because the board has authority to do so when they're renewing their license. And that's what we decided to do. It's just to, on an ongoing basis, if anybody's trying to renew a license or, even a new license, it's a case-by-case basis of that individual person's facts and information we have.
Or any other questions for Ms. Racine? You direct?
Yes, Ms. Racine, would you agree that the actions, that you don't have any specific evidence that Ms. Bodie was aware of the actions being taken by the school or any wrongdoing on the school's part? Do you have any evidence specific to this individual? Do you have any evidence that points to the fact that Ms. Bodie was aware of any kind of scheme, fraud, or actions being taken by the administrators at the school that she was attending? Anything specific to her to indicate that she was a participant in this, in whatever is being alleged?
Unfortunately, I was not part of the personal appearance, but normally the board member will ask the individual whether or not they knew. I don't know if that happened. I wasn't present in that personal appearance. And I don't know if she had asked that, but normally that's a series of questions that board members will ask during the personal appearances of those that were involved with the F-990 or identified as somebody who may have received a fraudulent transcript.
But what I'm asking specifically is, does the board in its file have any evidence that points to the fact that she was involved?
Outside of her name being listed in the affidavit and the updated affidavits that we continue to receive on the school that she received her transcript and the time frame in which those schools were issuing fraudulent transcripts, that is how she's involved.
I understand, but these affidavits are being signed by individuals involved in this who may be getting sentencing, mitigating factors, or are cooperating with the FBI. We don't have any way to establish that from the affidavits. Is that correct?
That's correct.
Okay. And would you agree that you indicated that the template letters that are sent to individuals who need to appear personally are just generic? And so in regards to a positive response, this letter specifically tells her to provide documentation related to the same. Please provide documentation that may be relevant to your positive response. So she would have had to take affirmative action to try to figure out what you were asking. If she looked at her renewal application and said, well, I didn't have any positive response, she would have had to take some sort of affirmative action. And my understanding, and if I may just clarify, my understanding of her prior testimony is that she was not provided some sort of directive list of what is missing or what specifically is in question. Is that correct? Thank you. And then would you agree that there is a summary on page 1 of the letter that was completed or sent to her on January 21st, 2026 was the letter indicating that her license was not reviewed. It was the denial. There doesn't appear to be in the summary, in the second paragraph, that the board is directing me to inform you that your application for renewal of your RN license in the state of Indiana was based upon Ms. Bodie attended MedLife Institute, reported that she received virtual education for didactic and lab courses, participated in a range clinical in New Jersey, lived in Pennsylvania, graduated in June 2016 from an accredited PM program. MedLife was in 2021. Her name appears on the listing of involved students that have been provided by the FBI. Recommendation renewal is denied. That doesn't appear to have any specific questions regarding whether she knew anything about what the school was doing. Is that correct?
Correct.
Okay. And in regards to the question regarding an individual that may have had a DUI but didn't report it on the positive response, would it be accurate to say if an individual did that, that there would also be a consumer complaint filed with the AG's office?
No, not necessarily.
So if an individual was not honest on their licensing renewal application, you're for the matter to the AG's office?
After the personal appearance, that's one of the recommendations the board can recommend, but not immediately.
Right, and that's what I'm asking, that if there was some sort of misconduct, this would be referred to the AG's office for
That's one of the options they have.
I don't have any additional questions for Ms. Gracie, and I just move forward with additional witnesses.
Board and recross, do you have any follow-up questions for Ms. Reese? If not, we'll move forward.
I would call Ms. Autumn Murphy, Deputy Attorney General.
I'll just wait a second, we need to start our admin.
Yes.
Right, well, there's themselves who is maybe witness if Ms. Cosby is standing raised right to be sworn. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give Ms. Cosby be the truth, the whole truth, nothing but the truth? Thank you. You may be seated.
Thank you, Ms. Murphy. Would you agree that this matter, we've referenced some of the documentations and I can show you, petition for summary suspension that has been filed, that was previously filed by your office. I believe you may have been the individual that filed it.
Yes, I was the deputy on the prior petition for summary suspension that was withdrawn before here.
And this is part of responding to that be accurate, the petition that was filed.
Yes, this is a true and accurate copy of the petition for summary suspension that was filed and later withdrawn.
And then additionally, there's a consumer complaint. Was that also received by your office?
Yes, this consumer complaint was received by our office. We opened an investigation file. We investigated and we closed it without further action.
And would you agree that that consumer complaint was dated February 7th, 2023? And the case closure letter that's part of respondents 2 is dated August 1st, 2025.
That is correct. Unfortunately, this closure letter is not saved to the documents portion of our case file, but there is a case note from our paralegal dated August 1st, 2025, saying that case closure letters were sent. So I cannot verify that this is the exact copy, but it seems that Ms. Cody received it. I can't verify it because we don't have this exact copy saved to our documents, and that is unfortunate. But the rationale for closure was insufficient evidence. I can't verify that as the deputy on the investigation file as well.
And would you agree, I made some statements regarding the Indiana Code. Would you agree that the Deputy Attorney General's office has the power to collaborate with prosecutors and law enforcement when there's evidence of a crime?
That is correct.
And obtaining a nursing license fraudulently or in any way, having fraudulent record is a crime, correct?
That is correct.
And in this investigation related to Ms. Bodie, is there any evidence to point to any wrongdoing on her part, or was there any sufficient evidence to move forward with either prosecution by the Attorney General's office or any other legal entity?
Our office did receive evidence that Ms. Bodie was listed on the attachment B to one of the affidavits that was received by federal prosecutors related to the Operation Nightingale investigation. However, the attachment B had some credibility concerns that led us to believe that there were individuals listed on the attachment B that may have been not properly investigated in terms of their legitimacy with MedLife institutes. Our investigation found that there were multiple MedLife institutes and that some individuals may have been placed on attachment B that were not properly supposed to be there because they were associated with other MedLife institutes with different school directors.
And would you agree that that information was received in 2023? And so the board would have been aware of her attachment to Operation Nightingale in 2023 and at the time of the AG's office case closure letter in 2025, is that correct?
My understanding from the narrative of the consumer complaint is that the former board director did have information that she was listed on attachment B, and that was the basis for filing the consumer complaint that we then investigated and closed with no further action.
Nothing additional at this time.
Or do you have any questions for Ms. Murphy? Thank you. May proceed.
And yes, I would just very briefly like to call the line just to clarify some of the issues that were listed in the denial letter. Ma'am, could you please state and spell your name for the record?
Ma'am, Gordy,
And how long have you been in the nursing field, ma'am?
15, 20,
Years?
yes.
And when did you first enter the field?
But, so I came from, Africa to Tennessee. And then, first I did, medical assistant, and then, went ahead and do a CNA. And then, from CNA, I did, practical nursing, and I worked with that for 4 years. And then later I went back to school, taking classes from music college where I was in, I had my, LP. And then later I did, RN.
Ms. Elkridge, can you have her form back in a little bit more, please? Speak real loud, Ms. Bodie, please.
Okay, yeah, so, later on, 2015, so I would find, credits and stuff that happened at community college, so I decided to, same, in the program with my class.
And when you received the initial petition for summary suspension, that was in 2023, correct?
Yes.
Okay. And then you received a case closure notice from the Attorney General's office in 2025, correct?
Yeah.
And that letter is part of our exhibits, correct?
Yes.
And you didn't alter that letter in any way, is that correct?
No,
And you have no reason to believe that that was not from the Attorney General's office.
yeah, I did. it was on there and they bring the.
And during your nursing career, have you ever been disciplined in any way? Have there ever been any complaints filed against you in any jurisdiction?
No, all my years of working as a RN, CNA, I have never had any disciplinary, action.
And would you agree that the letter sent to you on November 25th, 2025 indicated that you had a positive response on your license and renewal application, correct?
Yes,
And then how were you made aware of what the topic of the personal training would be?
so when I received a letter, so I, talked to myself, but I did not answer any positive because I've not done anything. So, when I called the board and then I said that if I've been in jail before, I said no. If I commit any crime, I said no. I said, but then, what the reason, you're asking me to come to the person in here? So they said that, they believe, stuff like, so we hold on and let me check. So once she told me, she said it was the teacher of the school that I went to. That was it. So,
Okay, and related to the school that you went to, did anybody offer you any kind of specific information as to what the issues were regarding your education or credentials?
no, just only said to the school that I went to. That's all I was told.
Did anybody send you any other letters directing you of what documentation you could provide or what evidence they were looking for?
No,
And you heard Ms. Racine testify to the fact that she believes that there was some communication given the fact that you submitted all of this information. Did you do that on your own?
yeah, because when you told me that, it was school, the house of the school where I went to, so I just got, sending stuff on the school that I went to.
And ma'am, do you have every single thing from school for those days or your classes?
That was 2015, the same years we're talking about. But I still want to get, some documents, for me to bring it to them. And that's a long time. Nobody can say that they went to school 10, 20 years ago and they would get every single document besides the one thing that they just renewed with the president is your diploma and your transcript. That's the only thing that, people can't really know to get what I ever, because I went to school was online, was a virtual education that we have these teachers come, and then we had a computer with log in, and then the teachers will come in and teach us.
And at the time that you were enrolled,
Mhm.
and paying money to the school, you believe that this was an accredited institution, is that correct?
Yeah, we checked it was accredited at the time.
And at the time that you were enrolled, were you aware of anything that was wrong with the curriculum or anything that the school may not have been in compliance with?
No, not that I know of, because when we started, the school was a good school. We did everything that we do. In fact, they hired, a deal in, because we was, from the East Coast. So they hired a deal in that, was making sure that we could get our clinicals done.
Okay, so, and in the letter where your license was denied, there is a summary paragraph that reported that you received virtual education for didactic and lab. And you testified a little bit that the school was virtual. However, were you also doing in-person work?
Yeah,
What kind of in-person work were you doing?
so the school was, virtual, but then, we always go when there's assessment, because there's this test that they want to also take every time that prepare us for entrance. So we'll go and do that assessment exam in further.
And in regards to your clinicals, where were clinicals?
I did my, clinical first, in, mental health in the message one, we did that in the hospital, nursing home, because genetic nursing home. In, Edinburgh, Pennsylvania, New Jersey.
And were clinicals arranged through a partner university?
It's the deal, we had, what meant like, hired. So the deal ended in New Jersey, but she was hired so to make sure that we get our clinicals done. So she always making this arrangement for us to do our clinicals. So the first clinical, was in a nursing home, and the last one was in a Princeton hospital.
And would that be
Yeah.
Princeton University Hospital in Princeton,
Yeah.
New Jersey?
Mhm.
And when you stopped for your NCLEX exam, what state did you sit for?
The other time I was in Pennsylvania, so I took my first exam in Pennsylvania. But then, I had a marital issue, it was just unbearable for me. So I took that test at one time and then I stopped, taking it because I was going through the divorce at that time. So it's part of the reason that I moved to India, because it was kind of a struggle for me, with that. So it took a long time, the longer time that I stopped taking it because my heart was not, okay. So later on, when I moved to Indiana, at that time, I was staying working with I had my LPN. So when I moved to Indiana in 2017, because I got my LPN 2009. So when I moved to Indiana, then I encouraged my LPN high school, so I started working with that. While I was getting better from my divorce, recovered from my divorce, and then start taking my English exam. So that's what happened.
And ultimately you passed that NCLEX exam.
Mm-hmm. Yeah.
And then ma'am, other than the consumer complaint filed, with the Attorney General's office regarding this, FBI investigation, are you aware or have you ever had to respond to any other consumer complaints filed against you in either Indiana or any other state?
No, I started in Pennsylvania, I lived in Pennsylvania 17 years ago, not a day, not one day. I started PNA, medical assistant, LPN, no.
Okay. And despite years passing since your education, did you do your best to provide even emails, memorandums, old exams, old study guides to show that you were attending a school and working towards a passing curriculum?
Yes, so I was able to send some documents, but most of my documents were not open. The reason is that when he and my ex-husband were going through the divorce, he sees the phone that I was using at that time that I was going to school. So at that time, my email was marybody@gmail.com. But then I have to change my Gmail altogether because when he took the phone, I could not remember, when I got a new phone finally, so I tried to kind of retrieve my emails. But then it kept sending the message, Google kept sending the message to the old phone. And he had the phone by that time, he sees it from me, so I was not able to get all my documents. But recently, my phone, it happened that my son has the phone. But if everything could not open, anything that it was a PDF file, it could not open, was some of the communication from the school says that, we had exam because they had a login for us, we were logging, and then we have classes. When they send it exam, they send it to that same platform, and then we take exams and stuff. They communicate with us in terms of clinical and everything.
And at the time, there was no issue with the accreditation.
No, we are there to 2016. I was waiting for maybe, I don't know what happened down the line, but we were not part of it at all.
And as it stands today, I understand that you can't access all of your past records from years ago, but at the time that you applied for licensing, you were able to provide complete transcripts and proof of your education, correct?
Yeah, it was coming from the school. When we applied to the institution to take your exam, the transcript come from the school.
And I know that you've already testified to this, but I do want to clarify and ask, have you ever paid anybody for a grade to pass you in a course or to give you a diploma or some sort of indicia that you passed a course that you did not do work for?
No, not from CNA, LPN, for assistant, and I always go to the school. There is somebody that scared. I don't do anything I don't want for my record or for me to get in trouble or even go in jail in this country. So I always do things the right way. And never buy anything.
And other than paying for tuition there, did you provide anybody with any money or any other gifts or any favors in order to pass any of the classes or receive your diploma?
No.
And currently, are you employed?
Yeah, for 8.
And has there been an extreme detrimental impact on your income?
Yeah.
Regarding your nursing?
Mhm.
I don't have anything additional at this time to this witness.
Or do you have any questions for this witness?
Yes. So Ms. Bodie, you said you received the letter from the board asking you to appear, and you weren't exactly sure why. But you said, after that you sent a bunch of information, I think was what you said. Did you call or email to clarify what you needed to send for proof?
I called because when you said positive, and I know I did not answer any positive on my applications, so I called. So what was the reason I was coming?
Did you ask at that time, what do I need to collect to submit or collect or be ready to give to the board for proof? Did you ask for some sort of a list? I'm trying to come up with how you said you sent us transcript, you said you sent your diploma. Did you ask for any clarification on, do I need anything else? Do I need syllabi or test results or, the different course requirements?
And my apologies, I believe that's been asked and answered. I did ask her and she testified to the fact that she called. The woman on the phone did not initially know. And she asked her, like, have you been convicted of anything? She indicated no. And she said it's a part of your education. I did follow up with a question that indicated, did you ever receive a list or any kind of initials with the documentation that you could bring or provide? And she said no, so she just sent anything that she could.
Yeah, yes, my question is, did you ask for a list or any sort of, thing?
Board, any other questions?
I don't have any additional witnesses. It would just be argument and so. As the board has heard, this individual has already been through an investigative process and what I would consider to be a stringent investigative process that lasted over 2 years. Ms. Racine has testified today that yes, the board is in communication with the FBI and receiving updated affidavits of individuals that may still be listed. However, in relation to Ms. Bodie, this particular nurse, that affidavit, information regarding that affidavit was received and regarding her name specifically was received in 2023. That was fully investigated. A petition for summary suspension was filed and there was not, the board at the time did not find the affidavits as sufficient evidence to suspend her license. And so, well, the board, not in this particular case, but the board found that an affidavit would not be sufficient to suspend a license in a different case. And therefore, the AG's office withdrew the petitions for summary suspension, but they did not stop the investigation. That investigation was ongoing. And as Ms. Murphy testified today, it was closed in relation to Ms. Bodie due to a lack of sufficient evidence. Ms. Murphy indicated that there were questions regarding the individuals listed, and she was one of the individuals listed, which resulted in that case closure letter. And so as we stand today, there is no evidence to indicate that she did anything wrong, that she didn't take these courses. There's no specific evidence to indicate even what is missing out of her education other than the school that has since been obviously in violation, is no longer accredited, is no longer in existence. But these individuals that attended the school, there's no specific evidence tying them to any kind of wrongdoing. She's testified to the fact that she took assessments. She's provided as much as she can to the board to show that. And I think if you look, some of this email communication, syllabi that she's providing, rubrics, they do show that she was attending a legitimate program, was in communication with the educators. She testified to the fact that she did clinicals, and she testified to the fact that she has almost 2 decades of experience in the nursing field. I mean, this is not the only place that she attended. And so it is my position that she is being retroactively punished for something that she complied with the investigation, was thoroughly investigated by the prosecutorial agency of our state that has the ability to sanction or ask for sanctions for licensees. And they have chosen not to do so because there's been a sufficient lack of evidence. It's my position that a mere 10 to 15 minute personal appearance in which she was not represented by counsel, never provided a list of specific things that were deficient in order to be able to try to, address the board's specific concerns is not sufficient to deny her renewal of her license. It's something that is a constitutionally protected right. She has a property right in her license. I mean, that has been established by the Indiana Court of Appeals, and has been established that there needs to be due process if that right is going to be limited. And so I don't think that it was appropriate to deny her license renewal. We're asking that her license be renewed and that her compact license be renewed today based on the same, and based on the statutes and the case law that we have in existence.
Thank you. These proceedings according to the notice are hereby adjourned until further order of the board. Board? Thoughts?
Like, would you like a little bit, would you like me to talk about your authority to, do this even though the consumer complaint is closed? Would you like my advice? So, advisory, opinion is that the Indiana State Board of Nursing has the authority to require a personal appearance as part of the license renewal process. Under Indiana Code 2523-176, the board is charged with examining, licensing, and renewing the license of qualified applicants. And by submitting the renewal application, the licensee places their qualifications in front of the board for review. Indiana Code 2514E further authorizes a licensing agency to require a renewal applicant to submit evidence demonstrating continued compliance with their licensure requirements. If the agency receives information suggesting that the applicant may have committed an act that could warrant disciplinary sanctions, it may delay the renewal to investigate and take appropriate action. The statute also expressly contemplates renewal proceedings that include personal appearances before the board. That's Indiana Code 54G1. Additionally, AOPA, the Indiana Administrative Orders and Procedures Act, under AOPA, the applicant bears the burden of proof. Indiana Code 421-5314C provides that at each stage of the proceeding, an agency or other person requesting that an agency take action or asserting an affirmative defense has the burden of persuasion and the burden of going forward with the proof of the request or affirmative defense. And by seeking the renewal, the applicant assumes the burden of demonstrating that they are qualified for licensure. So the closure of a consumer complaint does not foreclose the board from exercising its.
And I should object, because there's not a question to advisory, and this is quasi testimony and quasi legal opinion. And at the very least, I would like to respond to that. I understand that the hearing is closed, but I would like to respond to that because there are, I think, other statutes that are also implicated that are relevant to what is being presented.
And I would say I'm advising my client as to my advice, and the applicant was given their opportunity to present their evidence and their arguments.
Board, how do we feel? Or do we feel like we're ready to deliberate?
I feel like she's our advisor though.
I'm sorry?
I feel like she's our advisor and I don't know that she was done in her advice. I understand the objection, like, so I think maybe we needed to talk about that and how we feel about that.
I just would like an opportunity to respond regarding, the
I
evidence
heard her
position.
question.
It did sound like it was more testimony than advice. I would agree with that piece of it, but.
I would disagree with you, that it's more testimony than advice, so we're just reading that statute.
I was just giving you the statutorily makeup that gives you the authority to make this decision.
Yeah, which we asked for, or I asked for clarification.
And I do think that the point, Laura, that I was getting, I was making a legal conclusion. So I do think that the very last comments that I made can be stricken, but I think that when I was going through the code provisions, I think that those are the codes that give you the authority to require a personal appearance on a renewal following the closure of the complaint.
Okay, thank you. All right, board thoughts?
Microphone, please.
Sorry, so all we're looking for right now is whether to renew or not renew.
Yes, that's my understanding, yes, based on what has been presented.
So what may come to that, because I know it's like we denied her renewal and And her counsel is coming to appeal that decision.
That's
So
my understanding now.
do we need to decide on that piece if we feel like we've proven our case and decide from there? The renewal, or is it really we're deciding on the renewal? I don't know that I'm verbalizing what I'm asking here as well.
I don't think I'm sure. And as far as,
She presented a case against the previous decision that we denied them.
right,
And everything stems from if that college is legitimate or not, and have we found out if the education,
I think counsel's argument was that Medlife College in general had different locations that were in question. And this respondent was on the list attached to Medlife that could have been at a different location than what was originally under investigation, is my understanding. Is that correct?
that's my understanding based on Ms. Murphy's testimony.
I think there's two, I mean, to me, there's two issues. I have an issue that the letter said she was being dropped because it was a positive response. That's not true. So she called, to clarify. I think this is an FBI investigation. They're not gonna tell her. They don't know, right? So you're not gonna be able to give her enough. So she comes in front. I think it's, to me, then, because I get what you're saying there, but if I got a letter from the bar right now that said you need to come in front, and I hadn't been arrested, I mean, I might be like, hey, this is weird, right? Like, I don't know, right? So you try to clarify.
Yeah.
So then I think that's the first issue, but then the second issue is, was there enough? Because I don't think I agree with counsel. I mean, just because they don't have a complaint investigation doesn't mean that you can't, right, go forward. I think that's one part. So then she comes in front, but then what happened, and is it enough that she's on, all we have is that she's on a list. At this point, is that enough? Just that maybe it is, maybe it isn't, right? I think that's all you have. You can't, because they closed their investigation. The FBI, they're not gonna give us information. Even if you try, they're not gonna give you. So I think, is that enough?
I would say that we have many respondents come before us that have been on the list, and the ALJ that has seen it makes a decision off of what is presented, the questions that are answered, the
True,
documents.
but what about the reason why you're there and you're told one thing and it's not really?
I think those are two separate conversations. I was just saying, you said, is that enough? I'm saying, those have been heard.
Yes.
by someone, and they make a decision with what's in front.
Yeah, that's, because I haven't seen one.
I kind of see this as three parts. Like, one is the authority to act, and that's sort of what we were talking about first. And then second, I think is what Jessica's getting at, is like the due process arguments. And then third would be like, hey, does this person actually have the qualifications? Do you want to talk about, we had already talked about the authority to act, just the board think that they have the authority to act?
Yeah.
Yes, I think in my opinion, I think that's been established.
And then these are a little bit unusual proceedings. Do you want to take a vote on that to formalize that part of it, or do you think that we're okay to proceed?
I know you're in discussion, but if I may, that was not the issue that we brought. We never questioned the board's authority to act. We questioned the disparate treatment for this individual.
Okay, so I still think that we just continue on. I think it's improper to take questions. It's not our precedent that what we do. So I don't know if, I think the disparate treatment, I think that was explored upon. We can add that in if you would like to. But even though they didn't bring it to the board, they have the authority to act.
Yeah, I don't think anybody thinks otherwise.
Okay.
I don't think that's been our.
Okay, so then Jessica had brought up the due process issue. Would you like to talk about that?
So I don't know. Okay, so and you help me here. So if I'm getting information to come in front of this board and it's not accurate, the reason I'm told, what happens from there? Like if I'm told one thing and it's not, and I'm not saying it's on purpose, I'm just saying, right, like, and then I come in front of the board and that's not the reason why I'm coming in front of the board, there's another reason, which might be valid, right? Like, I'm not saying it's not valid. But that's not, what happens then? Does that make sense? I don't know if I'm like, I just am trying to follow with that.
So here's where we're at now. We have to decide. So the personal appearance notice referenced a positive response. And
and the applicant appears before the board, but that wasn't the case. We have to decide, if that defect in notice is going to be the error. So, but in my opinion, the, person appeared before the board, was given the opportunity to present evidence. They did. They received a written notice of denial, and now we're here and they're having a full evidentiary hearing. So this is her due process in my opinion.
Okay, that's all, that's what I need to know, because I just don't know that that negates. You know, 'cause I don't think she was brought in, I think there was a reason, and I think it was legitimate, it's what she was brought in, I just didn't know the notice. The difference, but that helps, thank you.
Incidentally, how did we treat the Nightingale nurses? Did we say no to all, do some?
I believe the ones that were noticed all came before personal appearances and saw an ALJ and had the opportunity to present evidence. And the ALJ made a decision with the evidence that was in that moment. So I think those decisions vary dependent on what was presented. And I believe there were various, correct me if I'm wrong, there were various ALJ members for that.
And we've had some consistency for one particular board member who's handled most of them, but they are given an opportunity. So it's not like we just say same across the board, and it's with anybody that's coming before us, it's that opportunity to present decisions based on that evidence.
But if you don't know what evidence you're supposed to present, that's a problem. I think we have to be careful with this because I don't know about her education. I don't know about the FBI list. The process of this that worries me the most is the fact of this due process. Do I believe we have authority to act? Absolutely. I'm not sure about due process. As far as qualifications go, I would like to remind you, she did pass the NCLEX. So based upon her knowledge, skills, and experience, she does have the experience required to pass the NCLEX. Maybe her education qualifications are different. Maybe they vary by state. We don't have really any kind of like education evaluation that says like, you absolutely can't accept this. I don't, none of this feels good.
I feel like that,
On both sides.
I think simply, like, I've never seen where it's just, I mean, one of the evidence of an FBI is telling us to do this. But I mean, that's basically what that, and whether that's true or not, but I feel like I don't, in other situations.
Just because the FBI president doesn't necessarily mean it means, and
Yeah.
FBI get shady stuff
Yeah.
from people all
Yeah.
the time, trying to cook deals.
Yeah.
Like, I
know, that's where
I just think that is a little premature. Do I believe her education is valid? I don't know.
Right.
But do I believe that we have someone with the knowledge, experience, and education to pass the NCLEX? She has already done that. So every single time she comes to renew, if we renew her, are we gonna do this again? That's the question, because that would not be fair.
Yeah, I agree
So
that.
I think once we decide, like, we have to put a pin in this and be done it.
That's where I'm torn as well, is I don't know when we were receiving, the board was receiving new information, were they reevaluating past, the past people that come before the board in light of the new information? It doesn't sound like it, and that would be, I think that would be very complicated and hard to do, and probably not something that we could even appropriately do. But just because she is coming later, when we have more information, then is she being held to a different standard? And having said that, she did pass the NCLEX, but I also believe in the value of, you know, a complete and appropriate program. And so I'm really torn on this.
It actually says they have to have both. You can't just pass NCLEX and not have that education requirement. For me, I hear what you're saying. For me, it's not so much about all of those pieces. It's whether her name was attached to a list with the wrong college. That's my concern. Versus like the other pieces of, because I do think that we hold people accountable from getting an education for that meets certain standards. And if that doesn't happen, regardless of whether they pass the NCLEX or not, we have held those people accountable for that. Unfortunately, I think some of the argument was whether this person was knowingly doing something, and that's not really part of this.
Yeah.
what part of it is whether the school, whether they deceive people or not, that's very unfortunate for those on the negative end of that. I think there are some students that did it maliciously. I think there were some people who were scammed.
So can I throw one thing in when you're done, just so
I guess, to me, I think we have to decide, is there enough evidence to show whether she was appropriately on the list or not? Or what was presented, because I think the ALJ made a decision with what they had at the time.
Yeah.
Which we all subsequently voted on, right? It came before the whole board and we all voted on that. So I think the question is, do we have new information today that would make us think differently than what we voted on before?
So I just want to throw this out for consideration, and I know it's not apples to apples, but like, there have been many times, and I think one of the today, where we have a program that falls below standard, should not, is not, cannot, will not be accredited. So we don't, like, when those nurses go to renew, you know they're in a substandard situation, but hey, they passed the NCLEX. I
don't think what was under investigation was whether they were a sufficient program. It was whether they were falsifying that people were getting an education. I mean, we've had people who said that they were flying to Florida once a week. And when we asked them why they weren't attending programs that were local, it was like, I can't afford it, but you're getting on a plane once a week. Like, that doesn't make sense. So I think that there was some.
That's not relevant to her.
No, I agree, but I think bringing in a conversation about an accredited program and this are also two different things. In my opinion.
All right, board, is anybody leaning towards any one particular direction? I'm sorry, I could not hear you.
I said I was leaning towards regional.
Can you elaborate on why you're leaning?
Just, it feels like she's presented enough stuff that makes it, she's not trying to hide anything. She's turning in all this paperwork, she's sending emails, she's sending transcripts. She did her clinicals at Princeton, they weren't applied like ninth place. It just feels to me like she made the effort, and whether the school ended up taking her in the end, I don't think it's not her fault, but, and it also sounds like with some of the schools, they were reputable up to a certain point, and then they just kind of dropped off. And when she was in it, she felt that it was legitimate. It seemed like everything that they were doing was legitimate when she was there. And then when she sat for the boards, they were saying, yes, it's an accredited school and legitimate. So I just feel like she's made the effort and done everything correctly. And just feel like, plus the years that she's been practicing, just feel like she's not a danger.
Yeah, just for my 2 cents, I'm also leaning that direction. I think with everything that's been presented here, looking at the rubrics, looking at everything, I believe her testimony is different than some of the other ones that have come before us that we were saying. I also am leaning more towards this testimony that Ms. Murphy had given. Potentially there being 2 different schools, all of that. I don't think that we have enough to warrant a denial, honestly, because I understand that ALJ has what they have, 10 minutes or whatever it is to prove. I think we do have more evidence here before us. I do think that the state had 2 years opportunity and then wound up closing it out. So to me, that says a lot as far as the state could not find evidence that there was any wrongdoing. So to me, that is, I mean, even if I just discounted everything else, just basically listening to what Ms. Murphy's testimony, to me, that was more compelling. And again, I don't think we have any other reason to deny, honestly, just based on what we've been submitted today.
And I'm in that direction as well. I don't think there's been a lot of proof of that she was appropriately on the list. And depending on the time frame of all of this, it may be that she was participating in at that time what would be an appropriate program. I don't think we can prove that it didn't happen. So that didn't happen.
Why would we?
So it's more of a increase.
Yeah, and that's what I was just gonna say. One thing too, is it is her burden, but you also have to remember that the burden of proof is preponderance of the evidence, so it is a pretty low burden. So more likely than not, the 51%. So if you are thinking you're in the 51% area, that might help you reach your decision or anyone that has to make their decision.
All right, so it sounds like, Dr. Hayden, you have a motion. Would you like to state
I
it?
make a motion for renewal. We have to make a motion to reverse the design or anything, or you just.
That's, I mean, we can do it however.
We make a motion to reverse the denial.
I think it was, the proper, language would be to overturn the prior decision and to proceed with the renewal.
Make a motion to overturn the prior decision.
All right, so we have a motion on the table from Dr. Hayden. Do we have a second? Second from Ms. Morris. All in favor? Aye. Opposed? Abstain? You were, I guess, yeah, you were originally, so you don't have to abstain. So it sounds like the motion carries 8-0-0.
Deliberation is enough.
Yeah, we should catch it.
So overturned, there should be. I think that, in reference that the state closed the case. We have no, like, I mean, yeah, there's the list, but like, we haven't seen it, it's not been presented to us in any way. I mean, we have nothing really that demonstrates that the education that she participated in wasn't valid. Is that cover it? Does anyone want to add to that?
So how can we stop and make sure in 2 years this doesn't happen again?
It would be a violation.
What if we get more into the process?
Then if you get
What if FBI comes back and says, yes, this college?
It's not necessarily the college, it's an individual person that came to that college. So we're reevaluating all of these individuals, not the schools, to evaluate their education and make sure that they meet our state standards. So, moving forward, her name is not flagged in our system anymore.
Unless there was new evidence, right?
That's what I'm
Yeah.
saying.
Unless there's
There's new investigation.
If there's new evidence, that's different, but if it's just like, we're cruising along and it's the same bit of information, we can't do anything about it in 2 years. And I feel like, I mean, whoever's in our board director position would know that, like.
Okay. You have what you need.
Yes, thank you.
Okay.
Thank you for your time.
All right, at this time, we're going to take a 10-minute recess. Let's come back together. I just want to make sure that anybody who's out here is not here for personal appearance. Is that correct? Or personal appearance? Okay. So, that is in room 22. So you have to take, okay. She's going to show you where that's at. Anybody else here for personal appearance? Okay. So we'll continue to move on through the agenda then. Moving forward to motion to dismiss. All right, board, so we have a motion that is in front of us as far as the motion to dismiss.
If no one has any questions, we can do it.
Please.
Does anybody have any questions? Yeah. I don't. Okay.
Motion to dismiss. Make the motion to accept the motion to dismiss.
I'll second.
So we have a motion dismissed by Ms. Miller, second by Ms. Harlan York. All in favor? Opposed? Abstained? Motion carries. 800. All right, moving forward to the petition for summary suspension. In the matter of the license of Chandler Manless. This is an administrative hearing taking place on April 16, 2026, in room conference center, room C of Indiana Government Center, building 302 West Washington Street, Indianapolis, Indiana, at 11:24 a.m. Local time is being conducted pursuant to laws of the state of Indiana, found in Indiana Code Title 4, Article 21.548, members of the Indiana State Board of Nursing, and a cause document administrative cause number 202604 NUR 0094. The respondent's name is Chandler Mans. Notice was provided to the respondent in Attorney General's office as provided by law on April 10th, 2026, this hearing to determine whether the respondent's license should be summarily suspended based on the state's petition for summary suspension filed April 10th, 2026. My name is Jason King, serving hearing officer of the board of Paul members of the board are seated with me. Dr. Guy Inglis, Nancy Youngs, LPN, Dr. Hayden, Jessica Harlan York, Dr. Scalf, Jennifer Miller, RN, and Rita Majors, LPN. At this time, I request that any board member who believes that he or she cannot give this strong fair hearing and render a partial decision to remove himself or herself from this hearing. As a reminder, this hearing is open to the public and streamed live on the internet. It's the responsibility of the parties and council to ensure any protected health information or other confidential information necessary to the parties' case in chief be de-identified prior to disclosure. Failure to properly protect patient information could result in objection and exclusion of testimony of the witness. May we have appearance of counsel, please?
August Buckingham, Deputy Attorney General for the state.
And do you expect to have any witnesses with you today?
No, nothing.
Parties in this matter hereby notified that the board will take official judicial notice of its file and record in this matter. Do you have an opening statement for us, sir?
Just briefly, I spoke with Mr. Mans last week and he agreed to be voluntarily summary suspended. We uploaded the same day on April 10th, the BSSA agreement. He agreed to be suspended until July 15th, until the board reconvenes on July 16th.
And these proceedings according to notice hereby conclude this cause therefore adjourned until further order, board.
That's right. Except the,
Very good.
And second?
Harlan York, Ms. Miller, all in favor? Opposed, abstained, motion carries 800. Thank you. Thank you. Moving forward in the matter of the license of Catherine Drown. This is an administrative hearing taking place on April 16, 2026, in Conference Center, Room C of the Indiana Government Center Building, 302 West Washington Street, Indianapolis, Indiana, at 11:27 a.m. Local time is being conducted pursuant to the laws of the state of Indiana. It's under Indiana Code Title 4, Article 21.548, members of the Indiana State Board of Nursing. And the cost document is administrative clause number 202604 NUR 0096. The respondent's name is Catherine E. Drown. This is a hearing to determine whether the respondent's license should be summarily suspended based on the state's petition for summary suspension filed April 14, 2026. My name is Jason King. I'm serving as hearing officer for this board. The following members of the board are seated with me: Dr. Gallegos, ACM LPN, Dr. Hayden, Jessica Harlan George, Dr. Scow, Jennifer Miller, RN, and Rena Major is LPN. At this time, I request that any board member who believes that he or she cannot give this respondent a fair hearing and render a partial decision to remove himself or herself from this hearing. As a reminder, this hearing is open to the public and being streamed live on the internet. There's responsibility of ours in the council to ensure any protected health information or other confidential information necessary to parties' case in chief be de-identified prior to disclosure. Failure to properly protect patient information could result in objection and exclusion of testimony of the witness. May we have appearance of the council, please?
Deputy Attorney General Autumn Murphy on behalf of the state.
And ma'am, do you have any counsel with you?
No,
Do you understand that you have the right to be represented by attorney in this matter?
yes, I do.
And do you wish to proceed without an attorney present?
No.
And I would note that the state has made contact with respondents' criminal counsel. Criminal counsel is aware of today's hearing, and I'm not sure if criminal counsel is attending virtually or just declining to appear. But he has indicated to me that he does not intend to represent Ms. Drown with respect to this licensing proceeding, and that his scope is only related to the criminal matter. But because this is an emergency proceeding, the state would object to a continuance and would like to proceed with today's hearing.
Would recommend that you proceed. The state has made its burden of service and that actually above and beyond me contacting her counsel as well.
Objection to send.
I would like to correct an error that may have just happened. There wasn't necessarily an objection. The respondent just indicated that she would like to not continue with today's hearing without counsel. So the state would request a motion to continue by the board to create a record that there was permission to proceed with the hearing.
So I think that she was given the notice that she's required under the law. And this is an emergent situation. I would advise the board to proceed.
And board, do we have a motion?
Motion to proceed.
I'll second.
Here we have a motion to continue by Scout, seconded by Gallegos. All in favor? Aye. Opposed? Abstained? Motion carries 8-0. The parties in this matter hereby notify that the board will take official judicial notice of its file and record in this matter. Do you have an opening statement for us?
Yes, I have one preliminary matter I would like to address. Because the state will be discussing a pending criminal cause, the state would request that advisory make the proper admonishment to respondent about her rights with respect to the criminal matter and how they may be implicated in today's proceeding.
Sure. During today's proceeding, the board may ask questions related to the facts of your case. You have the right under the Fifth Amendment to decline to answer any question if you believe that your response could incriminate you or expose you to criminal liability. Exercising that right will not be treated as proof of guilt or wrongdoing. However, this is an administrative and not a criminal proceeding. The board must still make findings based on the evidence available. If you choose not to answer certain questions, the board may consider the absence of your testimony as part of the evidentiary record, along with all other information presented.
You may proceed.
The state will present evidence today of a pending criminal cause in White County that was filed in November of 2025. At the conclusion of today's hearing, the state will assert that the respondent represents a community danger if allowed to continue to practice as a practical nurse, and would ask that the board issue a summary suspension for no more than 90 days.
Thank you. Ma'am, do you have an opening statement?
No.
Okay, see, you may proceed.
The state calls Lauren Judd to testify. Ms. Judd, have you been sworn?
No.
All those who know themselves to be witnesses or may be witnesses in this cause, please stand and raise your right hand to be sworn. Do you and each of you solemnly swear or affirm under penalty of perjury that the testimony you're about to give in this cause be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may be seated.
Ms. Judd, can you please state and spell your name for the court reporter?
Lauren Judd, LAURENJUDD.
And what is your job duty, or what is your current position?
I am an investigator at the Indiana Office of the Attorney General.
And how long have you been an investigator?
5 years.
What are your job duties as they relate to today's case?
We investigate consumer complaints for licensing violations.
And what do you do in order to investigate consumer complaints?
We collect evidence, such as court records, DOE reports, and any information that pertains to the allegations.
As a regular part of your job duties as an investigator, do you review the Indiana Public Docket Management System, which is called My Case?
Yes, we do.
And let me back up 1 second, Ms. Judd. How did you become involved in today's case?
I was assigned a consumer complaint against Ms. Jones.
And prior to testifying today, have you had an opportunity to review the investigative file for this matter?
Yes, I have.
And I'd like to refer you to what has been pre-marked as State's Exhibit, State Summary Suspension Exhibit 1. Can you flip through that document and tell me if you recognize it?
Yes, I recognize this.
What is it?
It is the official consumer complaint that was filed against Mr. Jones.
And is this a true, fair, and accurate copy of the consumer complaint that you reviewed in our investigative file?
Yes, it is.
And how do consumer complaints end up in our investigative file to the best of your knowledge?
A member of the public would have submitted a consumer complaint to our office.
And is it fair to say that they do that by filling out an online form?
Yes.
And is it your understanding that that form then makes its way into our files through an intake process?
Yes.
The state moves to admit a summary suspension exhibit 1 at this time.
Ma'am, have you seen a copy of this exhibit?
Yes.
Do you have any objections?
No.
Okay. State's Exhibit 1 admitted into evidence.
What is the, who is the consumer or the consumer entity associated with this consumer complaint?
Indiana Professional Licensing Agency.
And what does the narrative disclose?
It discloses that Mrs. Jones was, her employer became aware that she had been arrested and was reporting that arrest.
And what is the date on this